Hey there, everybody. This is Christian Denmon. I'm an attorney with Denmon Pearlman in the Tampa Bay area. And I'm going to spend a few minutes here answering a question that my divorce team especially gets all the time. But we do get this question in all areas of civil law, which is if the other party's not going to play ball and turn over the documents they need to turn over, what can we do? I mean, is there anything we can do? Are the courts actually going to help out? How do we stop this? How do we get the other party to comply so that we can get through this process and get things done? So let's go through it. And before we start, just give me a few seconds here, and I want to show you what the rules are. Like, what are the different tools that we use as attorneys to actually get documents? Okay, and perhaps the most common tool that we use in Florida, it's the Rule 1.350 and Rule 1.351, which is when we're requesting documents. We're saying, hey, we want to get documents from the other party, but we don't necessarily want to go to a deposition. We want the other party to turn them over to us, and it's usually within 30 days. So this is probably the most cited rule that we use. And if you look at the bottom of this rule, and it's the same with 1.351, you can see here near the bottom that the party submitting the request may move for an order under Rule 1.380 concerning any objection, failure to respond to the request or any part of it, or failure to permit the inspection as requested. So this is a rule that we use when we do our formal request for production that spells out what the other party is supposed to do. And most importantly, it tells us where we can go if we need to force the other party to turn over the documents. So what does that look like? Well, here you'll see a sample request for production. Quite simply, look, it's just a formal pleading document that says, hey, court, we're letting you know, court, I represent Sally in this case. Court, I'm letting you know that Sally is compelling Joe or requesting Joe to turn over certain documents. And this is example I'm going to show you over here on the right-hand side. This is a divorce example, and you can see that there's going to be, I can tell you there's going to be a lot of documents that we're requesting because usually when you have a divorce, you have not just assets and debts, but you may have alimony that's at issue, or child support. And the long and short of it is we need a lot of financial documents to figure out things like income, asset valuation, debt valuation, business valuation, and the like. Another tool that we use is called it's the 1.370 request for admissions. So and when we're asking for documents, this one is not quite the same. And this one we're asking for admissions, and same sort of rules though, which is if the other side doesn't do what they need to do, then we can go to the court and make them do it. But with the request for admission, we got an even better thing that goes along with this, which is if the other side doesn't answer, we can choose if we want to ask the court to deem the failure to answer as meaning whatever we were requesting, that it's admitted. And now let me show you what this looks like so you understand, okay? So this is some sample requests for admissions that we did on a case very recently. And I want you to take a look at it. We see on March 10, 2017, this is a request that, in my case, my husband client was sending to his soon-to-be ex-wife. And the problem we were having is that she had taken a ton of cash out of a savings account, and she was just moving it into a bunch of other accounts. And so when we're asking for documents, we got a bunch of crappy documents. It's just a big, it was a big mess. So to try to narrow down the issues and pin the other side into a particular the answer one way or the other, we use these requests for admissions. You can see here we say, look, you withdrew $300,000 from a bank account and deposited, and in 30 days, the wife has to either say admit, deny, or object and have a reason for failure, have a reason why she's objecting. And what this means is if we get an admission, now we have a fact that we know, right? And in this particular case, we're pinning down a bank account so that we can go back and use some of those other discovery devices that we've already talked about one, and we'll talk about the rest. If we get a denial, hey, at least they're taking a position. If they object, we can go in front of the judge and talk about that. And in the big picture, if they are not answering, then we can consider that the answer to this is going to be an admission. We also use interrogatories. Okay, interrogatories are like questions where we make the other side make statements under oath that they are then bound to. Again, though, they have to actually respond, right? And again, with the law on interrogatories, if we look at the bottom down here, it says the party submitting the interrogatories may move for an order under Rule 1.380 on any objection to or other failure to answer an interrogatory. And if you've seen them before, great. If not, this is what they look like. Here again, we're representing Sally and we're sending to Joe certain standard interrogatories. And there is certain interrogatories of which there's a bunch of standard ones that we can start with if we so use to send them out. There are things like background information, education, and the like, right? So to answer the question now, what if the other party is not complying? Rule 1.380 allows us to file a motion. And that motion, as long as we do it right, and as long as we follow certain requirements before we file the motion, that's the vehicle that lets us get a judge's order. Because remember, these discovery devices, they're not judges, for the most part, these are not orders from a judge yet. So when a person's not doing what we ask them to do, we have to go to the judge and tattletale, in effect, to the judge and get the judge to make an order. Because once you have an order and you're not following a judge's order, then we get to go back to a judge and say, Judge, they're not doing what you said that they needed to do. So now I want you to, hold them in contempt of court or do all those powerful things that you can do as a judge. Okay. So we look at 1.380, and it says that whenever the other side's not doing what they need to do, whether they're not answering or they're answering, but they're not doing a good enough job with their answers, then we can file a motion asking the judge to compel an answer, as long as we first certify in good faith that we try to resolve the conflict. What that means is if you have a request, a 1.351 request for production of documents, and the other side doesn't answer, and it's been 30 days, then we're going to send a good faith letter at day 31 that says, hey, you didn't answer, and I'm going to give you another 5 days or another 10 days to answer. So that's certifying in good faith. This is what that looks like. Here's a good faith letter. This is one that I wrote. This is actually suing Walmart. But the idea was that we had requested documents and those documents didn't come forward, right? We didn't get them in time. So we give Walmart a good faith letter and say, hey, you got 5 days to turn this stuff over. And then when they don't, which if you're dealing with Walmart, they don't, which if you know your spouse is going to be somebody that's not going to do it, then when they don't, you've now acted and done everything you need to do in good faith. So now you can go ahead and you can file your motion to compel. Well, what if they do request more time? That happens. Let's say that there's your attorney sends a good faith letter, and the other attorney says, hey, give me 15 days. This happened, that happened, the other thing. The reality is we need to be reasonable as long as they're reasonable requests. 10 days, 15 days, taking a long time, whatever, that's fine. But don't be unreasonable, right? The other side, if the other side's saying, hey, I want a month, I want 2 months or 3 months, clearly absent some unbelievable circumstances like somebody being in the hospital, that's not going to be reasonable. So it's important that we're reasonable. These are not exactly, they're bright line dates and timeframes, but we have a requirement that we work with the other side when it's practical and when it's reasonable. So if they don't turn it over, we file a motion to compel. And what you're going to see here is this is a form motion to compel, right? So in this particular case, we're going to state with particularity what it is that they were supposed to do, when it was due, whether they did it or not, right? In this case, we have a rule that goes along, and I didn't go over this earlier, but we have a rule regarding mandatory disclosure. In every case in Florida, every divorce case, there are certain documents that each party is required to turn over. And we almost always use these other discovery devices to ask for more documents because it's usually not enough. But nonetheless, 3 months of bank statements, 3 months of credit card statements, all these things are required. So in this motion to compel, we're saying, listen, there was a time frame for when the other party was supposed to turn over mandatory documents, and they didn't, right? And you also see here, this also says, hey, and we also sent a request for production of documents. Here's a copy of it attached to their motion. It was due at a particular time frame, and they didn't do it, right? Also, if you look over here on the right-hand side, we sent out standard family law interrogatories. Same idea. They were supposed, the other side was supposed to respond in X amount of days. They didn't do it. And so we're asking the court to compel and make them do it. A couple things when we're asking for a motion, we're doing a motion to compel and asking for court help. Is it the first time? Is this something new in the case? Even if you think the other side's going to be a jerk forever, is it like the first go around? And did they not do anything? Well, in a lot of jurisdictions, and I'm showing you sample language from Hillsborough, Florida's jurisdiction. Pinellas has some of the same stuff. In a lot of jurisdictions, if the other side hasn't answered, then we can do a written motion to compel and ask for the judge to rule on it without a hearing. And I think what that means your attorney can take a motion to compel and a proposed order and effectively mail it to the judge and say, hey, judge, will you just sign this thing for me and grant it? And then if the judge does, now you have your order and you're getting it pretty quickly. You're mailing it to the judge. It could get done in a matter of a couple of days. So generally speaking, if it's the first go around, the first request for documents, it's earlier in the case, they're not responding at all. We're looking to try to cut out the hearings and all the time that it takes to get the order, to speed things up and go right to the judge if we can in the mail and asking the judge to sign our order without a hearing. If you do have to go to court, some jurisdictions won't let you do this even on the first go around, right? Or this is not the first time this has happened. It's been repeated. If you have to go to court and your attorney's going to have to go ahead and put on a suit and get ready and drive down to the courthouse under normal conditions, we're not doing that right now, but have your hearing on the issue, then absolutely have your attorney ask for fees. Now, asking for fees might be the most powerful part of all of this when it comes to getting the other side to play ball, because nobody wants to have to pay for their soon-to-be ex-spouse's attorney's fees and costs. And if they do have to pay for it, they want to keep it as small as possible. And so if the other side is being a jerk and just not doing what they need to do, then getting into court at a certain point, bringing it up to the judge and having your attorney present an affidavit of attorney's fees, asking that your spouse pay $1,000 or $2,000 or even more because he's been running around and making a mess of things, that's powerful stuff. It really does go a long way to get compliance from the other spouse, even if it takes some time to get there. I mean, I promise you, there's nothing worse than when the other spouse gets blasted with an order saying he has to pay $2,500 in attorney's fees. And the other part of that is, if you get an order from the court where your spouse has to pay your attorney's fees, and then he doesn't do that, then your attorney can go back to court and say, court, he's not paying his attorney's fees. And that's really serious. That's right up there, not paying his attorney's fees, his alimony, or his child support are all really serious things that can get the other spouse. It can get orders so that he has to go to jail. So I've seen those. They happen relatively frequently. The other guy just keeps thumbing his nose at the system. Then the other spouse has to pay thousands of dollars in attorney's fees for not doing what that spouse needs to do with the documents. And then the court says, you know what? You need to pay these fees within 30 days. And then the spouse doesn't do that. And then the court will order him arrested. The court can do that. So recognize, though, that the process is not fast. I mean, you probably can gather that by looking at this, right? I mean, that's why we look at, can we go ahead and send this in the mail? I mean, if we can get a judge to order something without a hearing, we look at that to see if we can do that, because that's quicker than waiting for a hearing. Sometimes a hearing can be 4 to 8 weeks to get scheduled. Sometimes it can be quicker, but sometimes it can be longer. Every judge is different. What they have in front of them is always different. Every jurisdiction is different. you might have a judge that does a lot of family law, but they might have a tobacco trial in front of them. And by the way, those things are coming up in Hillsborough. We'll see what happens with COVID and everything. I'm recording this right now in April of 2020. But a tobacco trial could be 2, 3, 4 weeks. And if your judge has that, that could be 2, 3, 4 weeks where the judge isn't doing anything but that trial. Even in divorce, sometimes there are big, big, big divorces that can take 2, 3, 4 weeks. That doesn't happen all the time, but with big estates, big money, big witnesses, big things at issue, it can happen. So recognize the process is slow, and recognize that at first, all we're getting is an order. So when the other side doesn't do what they need to do and we get an order on our motion to compel, that's not the end of it right there, right? Because the other side, it's common for the other side who's been a jerk, for the first part of the process to then say, you know what, whatever, I'll just do it again. But also recognize now, though, that once you get an order, if the other side still doesn't play ball, now your attorney gets to go back in front of the judge and say, Judge, this isn't me. This isn't even the rules in Florida. Like, you told him to do something, Judge, and he's thumbing his nose at you. And you're the one on the bench, and you got the black robe, and you got the hammer in your hand. So what are you going to do about it? And a lot of times judges, as you can imagine, don't like it when the other side's thumbing their nose at them. Big picture, it can take a while, as you can see, for all this to go. I mean, it can be months. It's not uncommon for it to take a couple of months to work this all the way through when you have a spouse who's just thumbing their nose at everything. With that said, more often than not, just starting this process, just having your attorney on top of it, filing the motion to compel, often just having a hearing set on a motion to compel can be just what you need to get the other side to comply. It's very common to have a motion to compel set on a Friday. Thursday comes around and you get all of your discovery turned over to you. And then your attorney can decide at that point, is your attorney going to still move forward with fees? Again, each case is, you look at it case by case, fact by fact. If it's the first time it's happened, then your attorney may hold back on asking for fees and hold it in abeyance, and say, hey, at least we got this issue resolved. Now we can move your case forward. Hopefully we have what we need. We can get this to mediation, or we can get this settled, or whatever the case may be. If this is a repeat process, then you're going to see your attorney is going to be much more aggressive with pursuing fees and bringing the hammer down on your spouse. It's a rinse and repeat process. We have to file the motion, get our documents. Sometimes you have to file multiple motions. It's not uncommon, as we figure things out with more complicated cases, to file multiple requests for production. Especially if you have small businesses. Sometimes we don't get everything right away. Sometimes it's because the other side's a jerk. Sometimes it's because they don't know what's important and they don't understand. Sometimes it's because we don't know exactly what we need with the first or second request for production. But after getting some documents, we go, we talk to our accountant. Oh, we see everything we need now. I get it, what we need in this particular case to help figure out all the facts I need from my client so that I can make her argument so that I can get her the result that she needs. What can we do to speed up the process? One of the best things that you can do, it's yes, your spouse needs to listen and play ball. Yes, if you request something from your spouse, they need to turn things over. But what are those things you're requesting? Is it bank statements? Well, get it from your spouse, but don't be afraid to consider subpoenaing banks. Is it financial documents from your spouse's employer? We almost always subpoena documents from employers at the beginning of the case. We talk about it with our client because sometimes with small employers, there's exceptions. But if the other spouse is making good money and has benefits and retirement, maybe they have a golden parachute, maybe they have commission structures, who knows, right? But if the other spouse is working at a big firm or a big company, we're almost always at the very beginning, just cutting out the middleman, going straight to the company who has a legal compliance division and saying, give me the employment file. Because that's where you're going to find all the information that you need, especially if the other spouse is something more than a W-2 employee, especially if there's a bunch of benefits that are in play, or especially if there's unique commission structures or payout structures, or stock options, or dividends that are in play. So consider going right to the source. That really speeds things up. This is the rule I'm showing you right here, a 1.410, which is the subpoena rule, which says that, hey, as an attorney, I have the right to go to any third-party company or any third-party person I want to and ask them to produce documents. I can ask them to come to court. I can ask them to come in for a deposition so I can chat with them, but I can ask them to bring in documents so I can review them. Again, banks, financial institutions, brokerages, I mean, perhaps the financial planner for you guys or for your spouse. Accountants are a great source of information. Now, there are accountant privileges that come into play about what they're allowed to tell us, but those privileges, generally speaking, don't apply to documents. So whatever documents the accountant might have, and this is especially important when you have small businesses. There's a bunch of documents that go in that the small businesses will use, that the accountants will use to then create profit and loss statements and balance sheets and the like. And so often we want to get that supporting documentation because we may not trust that the accountant, either intentionally or unintentionally, we may not trust that they did the P&Ls and the other business documents correctly, and we don't want to leave something on the table and take some accountant's word for it. And again, the other party's employer. I mean, this is just most cases. This is what you want to do where the other person lives or the other person is employed by some sort of big company. And while I'm talking about the divorce perspective, particularly right now, a lot of times you might have enforcement issues or modification issues. You might have a spouse that's saying, hey, I'm not making enough money right now, so I need to reduce my child support or I need to reduce my alimony. Why would you take his word for it? Why would you take the documents that spouse provides? Why not go right to the employer and figure things out for yourself? Another thing that speeds things up, take a deposition of the other party or his friends, right? Sometimes attorneys will want to wait to take the deposition, if at all, of your spouse until closer to the end of the case. And sometimes that makes sense. But it's not uncommon when you have a situation where everything's taken too damn long getting documents, or the other side is just continuing to goof around about things, and maybe you have a judge that's not moving quick enough for you, take a deposition of the other party. So we have a rule that forces the other party to, a deposition means that he's compelled. He or she has to come into my office or to another place, sit down across the table from me with a court reporter there, somebody who's typing away, and if we want to, a videographer there, and answer my questions. And my questions can be about, it can just be chatting about this and that and the other thing about your relationship and what he knows. But I can also ask him to bring those same documents we previously requested. I can compel him to bring those again to the deposition. And then if he doesn't bring them, or if he brings a set of documents that's too small, I can go through it with him and ask him, what did you do to get these documents? How did you get them? How long did it take? Where did you go? Is this a full and accurate set of these documents? Maybe we've asked for emails, right? How did you search for these emails? Where'd you go? Do you have Google? Can you give me access? And we can do all that. And depending on what his answers are, we might have something that's really good to bring to the judge's attention that will speed up how quickly the judge is going to make things work for us. Imagine your spouse coming in, sitting down under oath across from me and giving me a hard time, giving me shit, right? About what I'm asking him. Imagine that scenario. And I have it videotaped and I have the transcript, and clearly your spouse he's thumbing his nose at the system and by proxy thumbing his nose at the judge. Well, if I have that, I can attach that to emotion. I can play that in front of the judge. And this can be very powerful. So the benefits, we can make the other spouse bring documents in person. Can ask him under oath, where are the documents, why he doesn't have them, videotape it, show it to the judge later. A COVID-specific question that I've seen, and I've been asked this a few times, is everything shut down right now? And the answer is, I don't think so. No, I don't practice in every county in the state of Florida, and I haven't been in front of every judge. But to my understanding, every judge, or just about every judge, is still keeping the doors of justice open as much as they can. So in person, that's out right now. And that's under the Supreme Court order. No one can go in person right now to court unless it's like an emergency injunction hearing, certain criminal hearings, but otherwise you can. Jury trials have been shut down. So we don't, this is kind of divorce specific questions I'm answering here. And that's not really an issue because trials with divorce are non-jury trials. You just have the judge. But I will tell you that the jury trials, they are shut down. And that's because you have to get 50 people in a jury panel and bring them in and ask them questions to seat a jury. Can't do that right now. But what we can do, and what judges are doing, is they can still rule on motions, hearings, mediations, and other things. And the judges are doing that via phone, or they're doing that via video conference. So judges do have discretion with how they want to do it. So just because I haven't seen a judge yet that is completely shut down doesn't mean that there aren't some judges, maybe even some older judges, that are shutting everything down right now. But I would be surprised because judges need to keep things moving as much as they can. So, and they don't want things to back up and back up and back up. And even if there's 70% of what they normally do, if they can do that, they're going to want to do that. And part of that, as you've seen here, is discovery. This stuff doesn't require a very long hearing. This stuff doesn't even require being in person to swear in testimony. I mean, imagine if I'm going in front of the judge and saying this other party hasn't turned over documents. I don't need my client to swear under oath to what happened. I can just tell the judge, look at the docket. He didn't turn it over, and I'm relaying to you he's not playing ball. So, but what can you do? What can you do to be sure? Call your judges. That's the bottom line. Call the judge. There is a judge assigned to your case. So if you ask your attorney, but if for some reason the communication is not there with your attorney or your pro se, just call the judge or email the judge if you have the judge's email. Say, hey, how do you want to do this? Some counties, some judges are saying, I really don't want to have a hearing on your motion to compel unless you really need to. I'd rather you do it by submission. I'd rather you just send me your motion in writing, and we can do that in Florida. And certain counties are that much more than others. But you can have a hearing by paper, which is you write in your motion exactly what you need to say. You give the other side 10 days to write their response motion, and the judge reads the motion and then makes a determination based on that. So see if that's an option. Again, see if you have the option that you can just submit your motion and ask the judge to rule on it because you have an administrative order on it. Same kind of concept, but a little different with discovery stuff. Or if you need a hearing, ask the judge if they're doing phone hearings. We did have I did see a question. Somebody was asking me about Lee County specifically. So I just wanted to show that person that you can Google Lee County Judicial Directory, and all the judges will pop up with their phone numbers and their schedule, by the way. And what I did see, now again, I didn't call any judges in Lee County. I don't have any family law cases personally in Lee County. I spend almost all my time in the Tampa Bay area. We move around the state when we're co-counseling with other attorneys. But in this case, I don't have any of my own cases in Lee County, so I call any of these judges. But I did take a quick look, and I just randomly selected a judge in Lee County. And this judge you can see right here. Now he's civil. It doesn't look like he's divorce specific. I can just tell by looking at these cases here. It's not husband versus wife. Construction group, but he's civil. But on today's date, April 20th, this Judge Fuller in courtroom 4N, he has a motion to compel. You see it right here. I see the motion to compel deposition testimony. So stuff that we're talking about, some judge, at least this judge over here in Lake County, had heard this exact issue this morning on the DeVito versus Black case at 10 a.m. So I would definitely call the judges. Final thought. If you already have an attorney, communicate with your attorney. You have to communicate with your attorney. In a divorce group, and I'm going to be posting this in a divorce group that my firm helps moderate, seeing some people mentioning having hard times communicating with attorney A, and then hiring attorney B, and maybe having a hard time with communicating with attorney B, and then asking attorney C to talk. And that's just too hard. That's too hard on you. You need to, that's part of what attorneys are there for, so get on the phone, push the issue. If you have a problem with your attorney is not communicating with you, that's a real issue, obviously, right? So, and hopefully that's not happening too often, but I know sometimes it does happen, then call multiple times, document it, email multiple times, document it, and ultimately you probably have to find another attorney, because you're going to be much more relaxed. You're going to feel more comfortable with this process if you're talking to your attorney and understanding what the game plan is, and then potentially meeting back with your attorney in a week or two and going over it again to make sure the deliverables that you expected that were going to happen, that they actually happen. So hope this is helpful. I hope this answers the question in a thoroughly, so you can see this is exactly what we do. By the way, this is what we do at my firm when we have to go get documents. We recognize sometimes it takes a little bit of time, but if we're thorough and we're proactive and we're on top of it, we're going to get the documents we need. And if the case gets delayed and it's not our client's fault and the other side's being a jerk, then ultimately we're going to make them pay for it. And sometimes even worse, sometimes people go to jail for really thumbing their nose at the system. Usually a party that maybe doesn't comply at first, usually when we're proactive, we put the pressure on, they come around and they ultimately comply. It happens much more often than not. So good luck to everybody out there. Any questions?